Hello, everyone. Good evening, good morning, depending on where in the world you're joining us from. And welcome to Legal Funding Journal's virtual town hall spotlight on Australia. I'm your host, John Freund, managing editor of Legal Funding Journal. I want to thank you all for joining us today. We've got a great panel lined up. There's a lot to cover here on the topic of Australia and what's going on in the litigation funding market there. So I'm just going to take a couple moments for some brief housekeeping. First of all registrants will receive a link to a recording of this event. You will be receiving an email post-event, so please keep your eyes open for that. The format of today's event, it includes a panel discussion followed by a Q&A with you, the attendees. So there's two ways for you to submit questions to our panelists. And you can do that via the comments feature of LinkedIn, or you can submit an email to jfreund@litigationfinancejournal.com. That's jfreund@litigationfinancejournal.com. We encourage you to submit those questions throughout the event, and we'll get to as many as we can, time permitting, at the end. We will also be hosting virtual town halls on a monthly basis. We'll be addressing themes and topics that are important to our community. And so we really hope you join us for those again at future events. Please stay tuned for those as they come up. And lastly, I want to say that Legal Funding Journal is the most comprehensive source of news and events taking place in the legal funding sector. So members rely on us to stay on top of case developments, funding activities, regulatory updates, and people moves, as well as to gain access to original content produced by some of the leading thought leaders in the industry. So for more details on becoming an LFJ member, please visit www.legalfundingjournal.com. And with that, I want to turn it over to our moderator, Ed Truant. Ed is the founder of Slingshot Capital, an advisory firm focused on investing in the global legal finance market, as well as other non-correlated alternative investment markets. He also serves in an advisory capacity as an operating partner with Northleaf Capital's private credit group. Ed is an advisory committee member of funds managed by Sage Capital Partners, a private equity firm focused on providing capital to the search fund industry. Ed is the founder of Balmoral Wood Litigation Finance, a fund of funds in the commercial litigation finance market. He was involved in the design, documentation, structuring, capital raising, administration, and investments of the fund. Ed received a Bachelor of Commerce degree from the University of Toronto and is both a chartered professional accountant and chartered business evaluator. Ed, please take it away.
Great, thanks, John. So just in no particular order, I'll review the biographies of our panelists. We'll start with Michelle Silvers. Michelle is the Chief Executive Officer and Director of Courthouse Capital and leads the company's business strategy, growth, and operations across Australia and New Zealand. Michelle is a highly respected leader in litigation funding, co-founded the litigation funding industry in Australia in 1999, and was a pioneer of portfolio funding. Before Courthouse Capital, Michelle had leadership and senior roles at leading international funders, global insurance firms, and in private legal practice. Michelle is also a co-founder and director of the Association of Litigation Funders of Australia. Our next panelist is Stuart Price. Stuart is the Chief Executive Officer, Managing Director, and co-founder of CASL, with over 30 years of experience in banking, investment banking, and litigation finance across the UK, Middle East, and Australia. He has held senior positions in litigation finance for over a decade, notably leading the resolution of a $190 million class action against the Queensland state government for stolen wages on behalf of over 12,000 First Nations peoples. As the inaugural CEO and Managing Director of the Association of Litigation Funders of Australia, Stuart played a pivotal role in its establishment and continues to serve as a director. He holds a first-class honors degree in applied mathematics from the University of St. Andrews and is a fellow of several professional organizations, including the Institute of Chartered Accountants in England and Wales and the Governance Institute of Australia. Our third panelist is Jason Geisker. Jason is a principal lawyer at Maurice Blackburn Lawyers and is head of Claims Funding Australia, the litigation funding arm and wholly owned subsidiary of Maurice Blackburn. Jason was admitted to practice in 1996 and holds a Master's of Law from the University of South Wales. He has acted in several high-profile class actions, such as the Iraq UN oil for food sanctions busting case against the Australia Wheat Board, and Volkswagen, Audi, and Skoda Dieselgate class actions conducted in Australia. For the last 7 years, Jason's worked full-time with Maurice Blackburn litigation funding business, Claims Funding Australia, focusing on commercial and insolvency claim type funding. Last but not least, we have Maurice Thompson. Maurice is a partner based in Australia with global sector-focused law firm Holman Fenwick Willen, or now known as HFW. Maurice specializes in maritime, international trade, commodities, and resources law, and has been advising clients internationally for over 30 years, 9 years of which he spent in England, South Africa, China, the Middle East, and the USA. In the litigation funding space, Maurice has successfully secured funding for large and complex claims involving shipping, cartels, mining disputes, commodity trading frauds, biosecurity losses, toxic tort, and marine pollution, with collective damages of over $1.5 billion. Maurice says quite openly that litigation funding not only transformed his practice globally, but also the way he evaluates opportunities and advises his clients. So given those great biographies, I'm sure you'll all agree that we have an excellent panel, well-versed in litigation finance industry in Australia. And with that, we'll dive into our agenda. I will note that we've had some technical issues with Jason, so we're not 100% sure whether he's going to be able to join the call in progress. But we're going to go ahead and start the agenda. So we're going to start off with some general overview of the market. The regulatory environment, let me go back here. Australia is a pioneer in the use of litigation finance. Perhaps you can set the stage for where it currently stands by providing an overview of the Australian market in terms of size, number of competitors, competitor dynamics in terms of entrants and exits, the typical funded claim types, etc. I'll start by calling on our ALLF founder and director, Michelle. Can you start us off in this discussion, and then we'll pass it off to Stuart.
Thank you, Ed. Thank you for the very kind introduction, and great to be speaking to everyone. So Australia has actually been involved, as you've all noted, in litigation funding for over 20 years, since the late 1990s. So I don't like to date myself, but the fact is that's where we all started. At the moment, it's an interesting environment. We have listed and private funders. We have hedge funds. We have law firms, and we have insurers. We have our market dominated by dedicated litigation funders, not necessarily alternative capital sources, which is what seems to happen overseas. Historically, we did have some funders who were predominantly participants domestically, local owned, and offshore funders have a small footprint now. That's my view. We've witnessed the market globalising with offshore funders entering and domestic funders expanding abroad. But a lot of those, as I've said, a lot of the offshore funders have withdrawn from the market. So the market is small. I mean, Australia's population is 25 to 28 million. So you can imagine that the way we operate here is quite differently to overseas. I would say, and I talked about this with Stuart earlier, that we probably have about 10 operating funders active in the market at the moment. The key players are of course, Courthouse Capital, CASL. We have some contingency law firms. I think Harbour, less so at the moment. LCM is a listed funder, LLS. Therium and Vannon overseas funders seem to have smaller scope at the moment. The new plaintiff firms have established as breakaways from older law firms running class actions, and there's only one large contingency law firm that I'm aware that's doing self-funding litigation at the moment. So our environment is quite different to overseas. It's a quite sort of smaller, well-knit funding environment. We all know each other very, very well. We often compete for the same cases, but it is fierce competition. But it's an exciting environment, I have to say.
That's great. Thanks, Michelle. Stuart, do you want to add some additional color and maybe comment a little bit on the nature of the claim types that funding typically supports?
Sure, and reiterate what Michelle says. Thanks for having the opportunity to talk. I'm going to mention a couple of things. Ed, on your website, slingshotcapital.com, if anyone wants to have a look at market sizing, 200 to 300 million litigation finance annual commitments is what you've estimated, with an estimate of about 700 mil commitment capacity. That will put it in perspective to the rest of the world when we talk about this small but perfectly formed environment of Australia. In terms of the competition, as we will discuss later during the course of this panel, Australia is a mature, is an immature, is evolving, it's dynamic, all of the above in different ways. And so the one thing that's probably remained quite constant is when you talk about claim types, class actions, commercial claims. Those commercial claims could be employment, it could be intellectual property, your typical breach of contract type claims. You have then the insolvency related claims, and that could be acting for breaches of director's duty, insolvent trading, etc. So those are probably the three key types. You expand further and you look at arbitration and some of the other areas around the world that are being funded, whether it's corporate law portfolios, subrogation, etc. All of those things are perhaps growing and evolving, but certainly those three, class actions, commercial claims, and insolvency, are the mainstay of this market domestically for claims within this market. Just adding to what Michelle has said, the market is much more than your traditional litigation funders. You have had law firms really, and we'll talk about contingency fees and the effect of that on the market, but large law firms have established through changes in regulation. But as Michelle says, I think there's about 10 active funders. There's probably about 12 so large, sophisticated plaintiff law firms that deal in class actions. But there's a multitude of other firms that offer no win, no fee, or those types of structures, so providing funding for litigation outside of that sophisticated large class action sphere.
Okay, that's great. Stuart, I'm going to stick with you for this next question. Michelle made reference to this in her opening comments about the market. It seems like there's been a number of funders, non-domestic, that have entered the market and either scaled back or exited entirely. Can you shed some light as to why that might be the case, and perhaps some of the challenges of operating in Australia?
I will keep repeating, it's a small but perfectly formed market. So the ability for scaling up is not necessarily there. As we all know, at this time, the time zone is an entirely different part of the world. So operating seamless global businesses is difficult, and operating a business from perhaps a desk in London or a desk in New York, you really miss what I describe as the fundamental 101 of investing. You've got to be on the ground and close to the action to actually understand the nuances in a particular market, and also when things don't quite go right, you need to be reactive and able to be flexible. So when you would talk about it, there was an influx of capital. I think that was how it's been described by many people. There was an influx of capital pre-COVID, when capital was flowing into this market globally. That encouraged some overseas funders to look at Australia as being establishing either a beachhead or a segment within Australia. I think that fundamentally, I always come back to anyone entering a market has got to have a long-term view on the market. Entering the market, unless you've been here with established players, you will always have new entrant risk, which is you will take on cases that you don't quite understand, and you must accept that you will lose some of those cases, which, as we know in litigation finance, can be painful. In terms of those losses, that they create learnings, and that goes back to that long-term view. But if you've got impatient capital, which is or capital that has a time frame on it, sometimes that's incompatible with that need for a long-term view. So my firm view, and others will most likely echo this, new entrants into the market have been few and far between. Those that have entered and stayed have needed to have a presence on the ground, and they've built that presence on the ground over time. Those that have exited or are operating from afar generally struggle within this market. And I think that just goes back to investment 101.
Great. Michelle, anything to add to Stuart's comments?
I think Stuart's 100% right in his observations. And the other issue is for overseas funders, if they don't have, as Stuart says, feet on the ground, they don't really understand the machinations of our system. And in the class action environment, in the last 5 years, there has been a restriction on the sort of returns that funders have been able to achieve. So the court ultimately approves any settlement. They approve what is returned to claimants and participants in the class action, and that the court also has the power to approve and vary the return or the commission that's payable to the funder. So for overseas funders, I think that's come as a bit of a shock, and perhaps it's altered the way they look at the sort of capital that they're investing in Australia as a result. And Stuart's right, you have to have feet on the ground. You have to have the relationships with the law firms. You have to have the relationships with the claimants as well in a class action and or in a case that you're funding, a commercial claim. And you need to work well with the lawyers. It's hard to do that if you don't have a very strong presence here and a build-up of a relationship. So there are a lot of factors that have changed the way I think overseas funders look at Australia. And that's great for us.
Yeah, absolutely.
I think one thing I'd add to that, Ed, I agree with what Stuart and Michelle have put to the audience. From a user perspective, yes, it is a very well-formed market here with the existing players. In terms of investment opportunities for funders and finance outside coming in, it is again correct that feet on the ground will enable the establishment of a regular business and flow and trust in this legal environment. But that's not to say that as a user, I can't readily get funding from outside the country to come in. I've done that 3 times. It does make the task of obtaining the funding a lot harder because you can't pop in to see Stuart or Michelle about the papers, and you have to sometimes educate, for want of a better word, the foreign funder or investor as to what the risks are here in the market. But that is still an opportunity, and one we frequently take up, though we do look very closely at our local opportunities here first. But it is a market that is open.
Okay, great. Michelle, I'm going to pick up on something that you mentioned in terms of return profile. I've been fortunately privy to a lot of litigation finance resolution data on a global basis. And generally, in my review of the data over the years, it strikes me that the Australian funders are perhaps some of the best and have some of the most consistent returns, albeit perhaps the quantum of financing is a little bit smaller than what you might tend to find in the US. Just generally speaking, do you agree with that? And what would you attribute the performance of Australian funders? Maybe I'll start with you on this one, Stuart, and then ask Michelle to add some color.
Look, I put it down to the predictability and probability of outcomes, and that really comes from the jurisdiction being established for a long time. Some of the growing pains that other jurisdictions are having are dealing with new problems, new issues for the first time within the laws, within the processes, also at the bench. So most of our bench that deal with litigation funding and the larger actions, they were junior lawyers, senior lawyers, partners, barristers, and now have become judges. So there's a an absolutely ingrained knowledge of the system, an appreciation of the importance of litigation funding to provide that access to justice. But that in itself is also goes with the Australian system. The civil justice system is an absolute Rolls Royce. It is gold-plated, it is costly, it is expensive, and therefore you need to know and be able to navigate your way around it, so that one of the more important things from a funder's perspective, duration risk doesn't become a hindrance to you. So when you talk about performance, I absolutely agree that Australia is up there as one of the better performing markets in the world. We select our cases well. That comes down to understanding the risk. We settle cases generally before trial, so 95% of our cases settle before trial. That brings duration risk down, which other parts of the world often struggle with cases going to trial and then going on through the appeals process. So I think it's that combination of factors that really are all a reflection of the 25 years plus of this existing in this market.
That's great. Michelle, anything to add there?
Only to agree with Stuart and to say that our system is very well advanced in terms of the duration of the cases, the speed at which cases can be dealt with. And I think the judiciary is all over how funding works. It's not a new product. So the judiciary is aware that a funder sits behind. The judiciary recognises that funding exists. So it's all about the case that you choose first. It's all about the law firm that you work with. It's all about the system of the federal court system or the Supreme Court system in each of the states. But our investors, obviously we're a private organisation, but our investors have had good returns because we've chosen the right cases. So, luck plays a big part, but I think investigation is extremely important. And obviously also having an insurer behind us to cover us in the event of failure or adverse costs, that's important. So we've been able to work with portfolio funding that suits us in terms of our operations. So we have several funds that exist, and the duration of cases and the use of our capital is important in working up the returns to our investors.
Okay, great. Just to give our listeners some context in terms of how Australia sits within the broader Asian context, do you find that funders there tend to view themselves, tend to apply a bit of a hub and spoke strategy where Australia is the hub for a broader Asian market, and they may have satellite offices in other areas, or they may just service the other Asian markets from their head office? Michelle, any comments on that concept?
I can't really comment, only because we're private and we're restricted here. I think a couple of the listed funders did operate that way. I can't say for sure that's. I mean, what do you talk about in terms of the Asian market? It's enormous. Yeah. There's a lot of work that's done in Singapore that I'm aware of. And yeah, one of the large listed funders operates there. But Stuart might have more to add, but I can't really comment.
Yeah, and to that point, Australia, again, anyone looking at it, the time zone is unfortunate because it takes us into different regions at different points of the day. Australia is a long way away from parts of Asia and culturally very different to parts of Asia. So I think that there is a recognition, and was a recognition perhaps, that the broader Asia could be serviced from Australia. But I think what has happened, principally arbitration up in Singapore, is one of the markets that may get service from here. The insolvency market is developing again in Singapore. You have emerging markets in Vietnam and the like. But realistically, I think like a number of jurisdictions, these are emerging markets that will over time fundamentally demand their own people on the ground in order to manage the same sort of risk as we see in Australia. As Maurice has said, there is global capital, the global finance providers. So, literally the provision of capital can happen cross borders to jurisdictions quite easily. But it's the active management, and I think that is really the component where funders bring that point of difference is you've got to have that knowledge, that local knowledge. If you're only providing money, then you're not adding value. And for all of us, I'm sure we aspire to ensure we add value every single moment we interact within our day-to-day business.
Great. So let's flip the page and talk a little bit about the regulatory and market environment. The regulatory environment in Australia has gone through some gyrations in the last couple of years, in part driven by politics. Can you provide an overview of what transpired and where the dust has settled and the implications this has had on the litigation finance market, both in terms of class actions and the broader commercial market? I was originally going to ask this of Jason, but it looks like I wasn't able to join the call. So Stuart, if I can ask you to pinch hit on that one, and Maurice and Michelle, if you have any commentary, perhaps you could add it after.
Is pinch hit a baseball term? Because I'm
it
not.
Is. It is.
Okay.
I don't know the cricket equivalent.
Look, I think the gyrations is probably an understatement. Gyrations in terms of dancing might reflect my style. It's been worse than that in terms of the political pressure. Certainly came back in 2018 through to 20. That coincided actually with the Association of Litigation Funders being established and having a seat at the table and a voice to politicians and lobby groups. But in that 2020 period, there really was the introduction of or rollback of an exemption that dealt with litigation funding class actions, representative proceedings, being treated as management investment schemes and requiring the disclosure that goes with any financial investment. So you literally went from an eight-page funding agreement to a 200-page PDS and FSG and a whole range of disclosure. So disclosure fundamentally, and Michelle touched on this earlier, disclosure is not something that litigation funders shy away from. It is a fact of the court needs disclosure and transparency. There are some things in disclosure that you shouldn't provide the defendant or the defendant parties because it's an adversarial process. But disclosure fundamentally is one of those aspects that Australia has embraced, litigation funders embrace, and we provide a level and a depth of information to the court to allow the court to assess the various risks. That period from 2020 also required funders to have an Australian financial services license. All of this was perhaps cynically a tactic to dampen the growth in class actions. There certainly wasn't, apart from additional cost and complexity, any noticeable benefit to consumers. So the fundamental claimants, the people that were supposed to be protected, were not necessarily getting any additional protection and arguably a greater cost. Fortunately or unfortunately, we embraced that change in regime. So again, if you're in the market for the long haul, there will be changes and dynamics that change in the market, including regulatory changes. We embraced that for 2 years. we had the joy of implementing the changes, and then we had the joy of reversing and unwinding the changes as the political parties changed in government. That in itself was somewhat frustrating because, again, there was a cost input and then a reversal of the regulatory settings. But really what we've had is some of those steps have assisted and strengthened the funders, the sophistication of the funders, the risk management of the funders. So the net effect of it, in my view, has been beneficial. Some funders were unable to continue under that regime and exited stage left. Moving forward, we have perhaps in the cycle a repeat again of lobby groups. US Chamber of Commerce is reported to be very active down here in lobby groups and defense firms and insurers, again, reiterating the same sort of noise that litigation funders are bad, this class actions are bad. As I've always said, there's really easy ways to eliminate litigation funders. That's get rid of bad behavior, corporate bad behavior, or set up public redress funds or something similar. So we've gone back through the same iterations of what we've been through before. I think we're better placed and are stronger because of it. But we embrace it and we accept that's the environment we operate in.
That's great. It looks like Jason's now joined the call. Jason, are you able to participate? Looks like you might be on mute. Okay, I'm just going to continue on. Maurice, maybe I'll ask you this next question. Up until relatively recently, outside of the class action space, lawyers have not been able to engage in contingent fee arrangements, but jurisdictions like Victoria have changed this dynamic. Can you provide the current state of contingent fee arrangement regulation and discuss its likely trajectory and the implications for the litigation finance market?
Yeah, thanks, Ed. I will answer that for you. I just think it would help some of our US viewers in particular to get just a little bit more context around us as a jurisdiction. Now, everything Stuart mentioned regarding this being an isolated part of the world or very far away from the rest of the world and the impacts that has on doing business here are 100% correct. A flip on that, though, for those listening is to realise that degree of isolation that we have had as a nation has always had us looking very closely outside of our borders. So we observe what's happening in other parts of the world, and that influences how we think. And while we're a fairly, jocular nation, we like throwing a shrimp on the barbie and all of that, we are very measured in our consideration of opportunities and how the country can bear fruit from that. So you might suggest, some of the comments you've heard might suggest that we're a slightly immature legal market in the sense that politics have impacted, courts have decided one way or the other, and there's been this degree of uncertainty since 2020. But again, I'd flip that and say, no, this is a case of us really looking hard at what we need moving forward and what will suit Australia. And the largest differential between us and our friends in the States, for instance, has been a perception among Australians and the judiciary and the public that we never have wanted to see a situation where the overweight child might sue the fast food chain because some lawyer provides contingent fee arrangements, children divorcing their parents, all those sorts of things. We've laughed at that scenario overseas, and we've never wanted that here. So this whole idea about contingency fees stirs up a lot of concerns in our legal environment and our public, and it's with having to deal with those negative perceptions that we have to think very carefully about how we structure moving forward. So here, as you've set up in your question, we haven't been allowed to have contingency fees. Since about 2020, though, the legislation changed in Victoria so that you can have contingency fees via various common orders in Victorian class actions. Now, again, for the viewers overseas, Victoria is just one state of eight, and it was the first piece of that puzzle unraveling or providing opportunity. So we've all been sitting back waiting to see what the other states might do. Apart from having the separate states with their separate Supreme Courts and their separate legislation or statute for US viewers, we also have a federal court system, and the federal court system has its own singular set of rules, and you can apply and be in the federal court in whichever state you might be. Now, the federal court has just this year passed judgment in a case called R&B Investments and Blue Sky. And the federal court, the full court of the federal court, has deemed that contingency fees are permissible as a matter of the rules dictating the powers of the federal court. So this is a real step in the right direction with our effectively national body of courts saying, yes, they have the power to order or confirm orders for group orders against all of your class members in a class action to allow the lawyers to take a contingent piece out of the recovery. That's not quite there yet, but it's a big step in the right direction because the court distinguished between their own powers to do that and the need for effectively the law to catch up relative to the lawyer's cost agreement with the clients, because under those rules, it's still not permitted /grey that you can have contingent fee arrangements. So we're inching closer. In the period between 2020 and now, there's been a proliferation of class actions in Victoria for lawyers to take advantage of the contingent fee arrangements. Not all law firms have done that. My law firm, for instance, we're running 3 large plaintiff class actions at the moment. We've got a couple in the pipeline. We're currently not fixated on Victoria because, among other things, the way it's been dealt with so far in this jurisdiction and with the court rules, generally, if you want to take full advantage of a contingent arrangement sanctioned now by the court and by our legislation, you have to wear all the risk of the costs. And then you have to wear the risk of a costs order or, security for costs order against the law firm. Now, most law firms, because this is new, won't stomach that at all. The partnership will not have a bar of it. But other law firms that have seen this as an opportunity, particularly large national firms like Maurice Blackburn, for instance, very large, has its own funding wing. Firms like that will jump at this opportunity because they can finance those sorts of risks. If I'm to sell that opportunity to my partners in London or Asia or elsewhere, it's a different proposition. So we are inching closer to a wider opportunity for law firms to take on contingent risk. We're not there yet. I don't think it's going to be the free-for-all that people have been concerned about. Again, that's not saying that there hasn't been a number of class actions flood into Victoria as opposed to going to other states under their state courts, the Supreme Courts here. But I think that will slow down, and certainly a firm like us are looking, constantly beyond the Victorian borders. And I'm in Victoria, so you would think, why wouldn't I want to be pushing my class actions here to get a contingent fee? Well, it's because I'm thinking long and hard about the pros and cons of that, and it's not all upside for the law firm. And again, that's where the relationship here, the very open relationship between funders and law firms seeking to use funders comes to the fore, because we know what's happening on the ground and we can have genuine discussions about, the pros and cons of where might we commence proceedings if it's not in Victoria. So, and the funders can and do come to the party for those law firms in Victoria that do wish to chance their arm with contingent fees, and the funders can provide finance to protect those law firms. But it's not for everybody, but we're really moving in the right direction. But there's always going to be that caveat that I don't think the judiciary or the legislature or the public will allow us to go, full on helter-skelter into, unchecked contingency fee type arrangements.
Yeah, very good. And from a funder's perspective, do you view this as a threat, opportunity, a bit of both, Michelle or Stuart?
Can I say, I mean, we've never seen the contingency fee position as a threat, because, as Maurice has indicated, it's only a couple of very large plaintiff firms that are able to provide their services on that basis for a class action. So for our model in terms of funding, we don't have a problem with it, and our relationships with the other law firms that we work with are preserved. And the big barrier for Australian lawyers to offer a contingency fee arrangement is the adverse cost exposure. So how are they going to overcome that, other than working with a funder to get an adverse cost arrangement through our insurers? That is a big problem. So unless you're really at a level where you're prepared to risk that sort of income as a firm, I think it's fairly limited. I'm not suggesting there's anything wrong with it. I just think that there's plenty of room for funders to still do very well in this market.
And now, Ed, if you allow me, I would just add to that. Absolutely right. Law firms have the opportunity here for contingency fees. Over time, and I think it'll be in the medium term, law firms will become funders and funders will become law firms. That's inevitable, looking at the rest of the world. Law firms presently don't operate like funders, and they've found themselves being exposed to this when in carriage motions or competition. They haven't got a suite of policies within their firm looking at concentration risk, capital risk, liquidity risk, key man or key person risk. All of these things are fundamental about capital management, risk management. They will, over time, be absolutely embedded within law firms. They need to be embedded in law firms. But at this stage of the market, we, CASL, are providing funding to all of the firms active in the GCO space. It is simply they are managing their own balance sheet risk, which they don't have a balance sheet capable of taking on the type of risk today.
Great. Actually, just as a reminder to listeners, that there'll be a Q&A session near the end. I have about another 5 or 10 minutes to go. But if there are any questions, please provide those in the comment section of the StreamYard stream or through LinkedIn. In the U.S. marketplace, there's been a lot of talk and some strong lobbying recently around the topic of litigation funding, contract disclosure. Can you provide us with an overview of where the Australian market is in terms of disclosure and the use of litigation financing? Maybe Maurice, I'll turn that back to you.
Thanks, Ed. I had a wry smile on my face because I can tell you in a nutshell, it's a current annoyance, a very high annoyance for me. Again, for some perspective for those in the US listening in, we don't have disclosure dealt with in the order that US courts typically do it right up front. We will normally have pleadings exchanged and there'll be a period of time before disclosure is made. In the class action sense and in the funded matters scenario, that seems currently to be turned on its head because as well, you have to declare in the class actions in some jurisdictions and some courts that you have funding, and then it has kicked off in 4 cases I've run and currently running, disputes with the other side about the disclosability of your funding agreements. It would be brilliant if there was one of our highest courts dictating in very black and white terms, not required, isn't needed, go away. But that isn't the case at the moment, and it is correct. And probably as Stuart was referencing, it's useful to have this sort of disclosure, particularly when there's this public perception that funding is bad because it's linked to class actions and class actions are bad. To get over all of that, disclosure or transparency is critical. What you can't have, and what has been sought in the 4 cases I've been dealing with recently, is an attempt to get at the critical terms of the funding agreements relative to what might be your plaintiff war chest for the case. So I've had absolutely massive, long-winded fights costing hundreds and hundreds of thousands of dollars on that very point. In one situation, it went all the way up to seeking the leave of our country's highest court in the land, the High Court, to do that very thing. So disclosure is needed. Disclosure benefits transparency in our whole discussion here, but it's not settled law, and it's constantly leading to expensive fights and the need to, in some instances, educate the bench as to why it's critical that we don't allow the entirety of the funding agreement to be disclosed. And I've got to tell you that that's gone very close to the wind in a couple of cases I've had where the court has otherwise felt, well, why not make this available? Well, if you make it available and someone sees you've got 10 million for your case, then they put their heels in the ground, make it long-winded, your length of capital tied up risk that Stuart was referring to before blows out, and it eats away at the ability to maintain that funding. So it's a brilliant, pretty obvious strategy for a defendant. So in terms of the whole wholesale access for justice conversation around why this is such a critical piece for Australia to embrace funding, then if you want access to justice, you have to look at it and say, well, no, it's not appropriate that we have full disclosure of this. And there should be a line in the sand that says, okay, disclose that you've got funding. Great. Disclose who that is. Great. Is that funding sufficient to cover security for costs or adverse costs order? Great. But that's it. Don't go deeper and wider, because then you're eroding the very access to justice arguments that have brought us to this table in the first place.
Can I do a follow on from that, just to say exactly that? We have, where there has been a request of the funding agreement by the defendants, we've provided the funding agreements, we've redacted deliberately, obviously, the provisions in relation to the funding, to the capital to be provided, so that there is no disclosure which would diminish the commercial viability of the claim and provide the defendants with the opportunity that Maurice has just described. So we've been open about the funding. We've wanted to assist the court, and the judge has been provided with a redacted version of the commercial funding, of the litigation funding agreement, and that's worked, solved the problem.
And in the interest of a topic for another time, if we want to have transparency, let's do it on all sides, defense and plaintiff. If we want to drop the duration and some of the unnecessary fights, let's see the insurance policy in full. Let's see let's have transparency. I think therein lies some of the hypocrisy and the cost and the nature of this Rolls-Royce justice system. There are better ways to do it, but we're coming from an established position where the plaintiff has got to bring the case. So we're being challenged by that defendant.
Great. Okay, I've got time, I think, for about one more question before we turn over to Q&A. Why don't we finish it off with a little bit of discussion around growth opportunities in the Australian market. I read recently that Pogus Goodhead has established an office in Australia, and I think that was mainly to pursue some litigation against BHP, one of Australia's, or one of the world's largest mining companies. And so I'm wondering if, and I also noticed that in Australia, it seems that you're doing perhaps a little bit more on the global mass consumer claims, the diesel exhaust, perhaps some medical products, pharmaceuticals, that type of thing. Can you talk a little bit about sort of mass consumer and perhaps even environmental claims, and where you see some of the opportunities in the Australian market? Stuart, I want to start with you.
Yeah, sure. I think Australia is a different jurisdiction in terms of the law, so not all claims that are run elsewhere in the world are suitable to be run here, won't be successful here, and that creates opportunity and also closes the door on some claims. I think the most recently Roundup claim, which was successful elsewhere in the world, was unsuccessful in this local jurisdiction. So we definitely see the growth, the opportunity for firms like Pogus Goodhead and others, and Maurice probably talks about having the cross-border global business. There are a few head offices, large head offices down here that demand attention, and so Pogus Goodhead being here for the BHP claim, plus other large claims that they may see elsewhere in the world. That's an advantage. I think probably the more important thing is our system since 2016 has allowed common fund orders and the ability to avoid book building, which was the old way of doing it. That's enabled the consumer claims to really grow. You don't have to spend lots of money signing people up for small, high volume, small dollar claims. You can achieve the economic outcome without doing so. But therein lies the holy grail, if you like, of the anti-class action, anti-litigation funding, as if they can remove common fund orders or the ability for these to be efficiently and effectively established without cost and time, then they can limit the number of claims coming. That's the sort of dark side and headwinds that affect it. But the country is embracing these types of claims, and will do so in the future. So Pogus Goodhead moving in, establishing an office, and having the funding capability of Gramercy behind them, that's a good thing. I see. Let's evolve this jurisdiction, and as Maurice also said, let's have the best parts of the rest of the world down here in Australia.
Right, Michelle. Any further comments?
Well, I think Stuart's right. There's great advantage to having those sorts of funders and firms around. I mean, Australia will always replicate some of these global mass consumer claims, and our records show that we've done that. There's a Johnson & Johnson pelvic mesh claim. There's a Toyota diesel emissions claim. There's a foreign exchange cartel claim that Maurice Blackburn are running, and then there's also other emerging class action areas that are coming through. There's the cyber data breach claims, and in Australia also there are workplace issue claims. We're involved in a very large action against McDonald's. There are environmental health claims and greenwashing claims. So there will be room for the larger groups to come through, and that's a good thing. I think that's a very good thing. I mean, our portfolio currently reflects a mix of class action and corporate claims. So we tend to ride a fine line in terms of the size of the claims that we want to take on. So I think Australia is open, but those relationships, as we talked about earlier, with the lawyers are important. But replicating what's happened overseas that is applicable for an Australian market is a good thing. So,
right. And if Canada is any indication, it looks like there might be some insolvency claims coming down the pipe soon.
definitely.
Okay,
Yeah.
listen, well, I think we've hit, we're just about 5 minutes from the top of the hour. I'm going to ask John to join the call and moderate any of the Q&A that have come in.
Yeah, thanks so much, Ed. Appreciate that. So I have a couple questions here. These can go to anybody, so whoever wants to take them. First question, what is the typical duration of cases in Australia for both commercial claims and class actions? And how do those compare to other jurisdictions?
I'm happy to answer the question in relation to commercial claims, because that really is half of our current portfolio. We advise our investors that it can be up to 3.5 years, 4 years maximum. And we've been running our portfolios with these commercial claims on that basis. 100% of the claims that we've been running in the commercial sphere have settled, and they've settled within the 3-year period of commencement. So that gives solid returns to our investors. And you know, our system, our federal court, Supreme Court system are really, really, really top notch in terms of moving things along fast. So
Michelle, if I can add to that. So on a portfolio basis, 25 years of data, 2 to 3 years duration on average on the portfolio. Insolvency matters about 18 months on average. Commercial claims in that 24 to 36 months, and then your class actions, you know, somewhere around that 36 months. So on a portfolio basis, as I mentioned, if you've got settlements and settlements before trial, you're getting the benefit of duration being shortened. So on a portfolio basis, 2 to 3 years is certainly what we target, and that's a reflection of the last 25 years.
Yep. Agree.
Okay, great. Next question. So how are GCs in Australia thinking about litigation funding? Is there the same difficulty convincing them to think of their department more as a revenue center than a cost center as there is in the United States?
I can respond to that. I think GCs, depends where they come from, but many of the GCs that we meet come from a property commercial claim type of law practice, and so they're not actually familiar with litigation, and it's a little bit hard to convince them about the advantage of litigation funding. But if they do come from a litigation background, I think they'd be prepared to embrace it. We find that our best approach is usually working with the chief financial officer of a business, because it's the bottom dollar. The bottom line is the dollar spent, and once they get their heads around the fact that there's no risk to them in engaging with the funder, and it takes the costs off their balance sheet, they can use it for working capital. That's when you get you get some decent response. But I think it's hard for GCs, so we like to work with them and the CFOs.
The delicate dance from a law firm perspective is wanting to have or to open up that discussion with the C-suite when you are ordinarily dealing with the GC office the whole time. So to not make it feel threatening to the GC's team, it's a couple of steps process to get their confidence to allow you to have with them the conversation with the CFO or the CEO or one of the C-suite in general. Make it less a challenge for them to have that conversation and doors open. And that's really where our firm sees the greatest opportunity for the use of funding here in this country. It's the use of funding for large corporates in singular type claims. And you know, with our isolation and our oceans and our resources and all the big players in our current market, there are opportunities there. It's the holy grail, getting the corporates to embrace what you have to offer and what the funders have to offer. They will get there.
All right, we've reached the top of the hour, so we're going to have to leave it at that. That'll be the final word. I want to thank you all for attending today's event. And I want to wish a special thank you to our panelists and our moderator, Ed Truant, who did a fantastic job. Really covered a lot of ground on Australia. So we hope you enjoyed this. As a reminder, you will all be getting a link to the recording of the event. That'll come within the next day or so. So please stay tuned for that email. And we'll be convening our community at our next virtual town hall in early December. So we'll be skipping next month, but then early December. So details to follow. And we do hope that you'll join us again for that. And for details on becoming a Legal Funding Journal member, please visit us at www.legalfundingjournal.com. Thank you again, everyone, our panelists, Ed, and to all of you who attended. Thank you so much.
Thank you. Thank you.